crazy breaking news out of the United States District Court for the Northern District of Illinois in Chicago. Really interesting order entered by a federal judge there that probably is not going to make anti-gun lawyers happy. Let's talk all about this exciting news when we get back. Hey folks, I'm Mark Smith, host of the 4-Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Check it out on Amazon. And if you have a copy, feel free to leave a review on Amazon as well. And if you're going to be out there in San Diego at the Gun Rights Policy Conference this coming weekend, feel free to stop by. We're going to be giving away some books there, going to be signing some books, doing some speeches and all that. So look forward to that Second Amendment Foundation event. I've been doing those events every year for the last several years, and I always look forward to them. All right, folks, so breaking news here. Very interesting. Now, I know a lot of you out there like to say, hey, Mark, what can we do about, lawyers and judges and whatnot that say things that we don't think are accurate? Is there any recourse or anything that can be going on? Anything we can do? Well, this is quite interesting. An order has been entered by Judge Ian Johnson, a federal district court judge in the United States District Court for the Northern District of Illinois in Chicago, where he is basically just called out, in a sense, we'll see what happens. He has called out a lawyer or lawyers who submitted a brief making reference to a mass shooting in Chicago. And he is he's demanding that there be a telephone conference on October 2nd, 2024, for these lawyers on behalf of the defendants, that's Kwame Rao and other defendants, to explain what they meant by something they put in a brief that they submitted to the court. Quite interesting stuff. Let me give you some context, and then we'll break down what the judge appears to be thinking. As you may recall, in the case of Benjamin Schoenthal versus Rao, this is a lawsuit that challenges the Illinois state law that bans firearms in public transportation areas, meaning buses and trains, even if you have a concealed carry license. Now, the whole idea of getting a concealed carry license is that you've been vetted by law enforcement and the government, and you have not been found wanting, meaning you're not a prohibited person under federal gun control law, 18 U.S.C. 922G, for example. So even if you have a concealed carry permit and you've gone through the process of being vetted by the government in Illinois, you still are not allowed to bring guns in certain quote-unquote sensitive places, which is a euphemism for government-mandated gun-free zones. Now, the state of Illinois said that you can't bring guns in places of public transportation, such as buses and trains, public buses, public trains. Lawsuit was brought, Schoenthal versus Rao, and Judge Ian Johnston entered an order indicating that he thought this violated the Second Amendment and should be enjoined. But he decided to pause, meaning to stay, his order to give the parties a chance to discuss whether or not his order should go into effect immediately, or whether or not his order should be paused or stayed pending the outcome of the inevitable appeal to the United States Court of Appeals for the Seventh Circuit. Because in Chicago, if you take a federal appeal, it goes to the U.S. Court of Appeals for the Seventh Circuit out of Chicago. We've talked a lot about Judge Frank Easterbrook and the like that are on that court, and that's where that appeal would go to that particular court. So in the briefing going back and forth between the lawyers for the defendants here argued that the stay should be entered so that Judge Johnston's order should not go into effect. And among the various reasons why they argued that the order should not go into effect is that there was extreme danger to society and to the public if Judge Johnston's order were to go into effect. Specifically, this is one of the points that the lawyers on behalf of the government defendants made. While the court entered purely declaratory relief limited to 4 individuals and 2 public transit systems, at least one news publication is now reporting that the court's ruling allows all concealed carry holders to carry concealed firearms in any train or bus in Illinois, signed to an article in a footnote number 7. Then it goes on to say, moreover, and this is the key line, folks, listen carefully. Moreover, the potential safety implications of this court's order are highlighted by a recent mass shooting on the CTA's Blue Line in which 4 people were murdered with firearms 3 days after the court's order was entered. Citing to a footnote, citing to the Chicago Sun-Times. So this is the argument that was made on behalf of the defendants to the court as to why his order should be stayed. Well, Judge Johnston did not take kindly to this, for he seems to be indicating that it is wrong to suggest that his order, which only applies to the particular plaintiffs in this case, all of whom are concealed carry holders, somehow could be implicated in a mass shooting involving some sort of a psychopath, apparently. So the judge schedules in the Schoenthal versus Rao case a telephonic hearing for October 2nd, 2024. And what does he want to discuss? Well, it's quite interesting. Let's take a look. The defendant's motion contains the following sentence, quote, "Moreover, the potential safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line in which 4 people were murdered with firearms 3 days after the court's order was entered," close quote. The court goes on to write, "The 2 signatories of the motion must telephonically attend the hearing. Additionally, if the person who wrote this sentence is not one of the signatories to the motion, then that person must also telephonically attend the hearing. Counsel should be prepared to explain what reasonable inquiry was done as to the legal contentions and evidentiary support for the factual contentions contained in the sentence," citing to the Federal Rules of Civil Procedure. For example, when in no way of limitation, counsel should be prepared to articulate the reasonable inquiry that was made to determine if the suspect in the CTA's Blue Line shooting possessed a concealed carry permit, and if so, whether he brought the gun onto CTA property to protect himself. Moreover, counsel should explain the reasonable inquiry as to how the suspect was protecting himself from the sleeping homeless people when he allegedly shot them. Wow, well that's quite something, because here you have a typical example, as I see it, of a lawyer party trying to defend a gun control law. And they basically just cite to stories of how nutjob psychopathic criminals, violent thugs, terrorists, whatever they are, have gone out and misused firearms. But we all understand that nutjob psychopaths, violent criminals, terrorists, gangsters misuse firearms. That's hardly a controversial proposition. But I think what the judge is getting at here, what Judge Johnston's getting at here with this order, I suspect, is he's trying to hold the lawyers accountable and saying, look, you can't just throw a bunch of spaghetti against the wall and call it an argument. You can't just say, here's an example of some nutjob somewhere in the jurisdiction misusing a firearm. That happens every day in Chicago. We get that. You have to tie it into the issues presented in the particular case. And here, when you're dealing with sensitive places, what you're dealing with is people that already have been vetted by the government and signed off on by the government who have concealed carry permits. They've gone through the process to get a concealed carry permit, to follow the law, to comply with the law. They've already done all that. They've been vetted and approved as not a prohibited person, as just normal law-abiding Americans. And yet, to argue that they can't bring guns into public transportation services like buses and trains and the like, you have the government lawyer here apparently signed to just a generic, violent, terrible crime committed by a nut job. It looks like that appears to be the case based on the reporting, at least, in my view. Shooting 4 people, murdering 4 people. It's terrible, terrible. But again, we do not measure constitutional rights in this country by virtue of the fact that they can be abused or misused in some way. We do not bar free speech for Americans just because a handful of people might defame someone or might misuse it or might use their voice to commit fraud. Just because that does happen and can happen doesn't mean we take away the right to free speech from Americans. Again, just because someone may use religion as an excuse to commit violent crimes or terrorist acts doesn't mean we take away other people's rights to exercise their religious views or their religious beliefs. So too, just because somebody can misuse an arm, commit a violent crime, doesn't mean we take away our right to keep and bear arms. That's not how it works. That's exactly what the Supreme Court has repeatedly said. And Judge Johnston here in Chicago clearly understands that. And it's going to be very interesting to see what happens on that hearing on October 2nd. We'll try to report it as the news reports come in for that day. But again, I certainly would not want to be the lawyer called to task and called to account by a federal judge over the insertion of that statement and try to explain how it connects up to, again, concealed carry holders who are lawfully vetted and should be allowed to carry everywhere, basically, because they've already been vetted, and try to tie that in with the judge's ruling. I can see why the judge may be a little angry here at the implication that his decision following the law and the Constitution is somehow the cause of these murders there in Chicago. And we'll see how the lawyer responds to it. We'll see what the judge does about it, and we'll let you know what the fallout is of all of this. But it's a very interesting development out of Chicago, and again, we'll keep you apprised as things develop. So there you have it, folks. Don't forget to follow me on X at 4Boxes Diner. I've got over 18,000 subscribers, or followers there, I should say. Make sure you subscribe to this channel and like this video. We're still trying to grow our channel, and we will see you again very soon here at the 4Boxes Diner.
Orders up. Table 2A.